do not have 5 more minutes to spare. So much work we have to do. So much learning. So much information crammed into our brains. Are you ready to cram the information into your brains? Yes?
I thought we were referring to the third song. Are you ready?
This is like the 3rd week. This is where our enthusiasm levels are. The 3rd week, your 2nd year.
It is Wednesday here. It's 9 in the morning.
It's Wednesday. It's 9 in the morning. That's right. That's when we do civil procedure. We love civil procedure. Today, before we talk about civil procedure, I have the highly annoying CBS News website up, which tells you about this judgment in the Johnson & Johnson versus Oklahoma case. You guys hear about this thing?
Yes,
Know what this is over? What's it remind you of? Or have you not been around long enough? All these states are filing suit against pharmaceutical companies. And the pharmaceutical companies are saying, well, it's not our fault. We just put a bunch of opioids out on the market and told doctors to prescribe them. Like a lot of them put pressure on doctors and healthcare providers to prescribe and prescribe and prescribe. And that's what happened. And lo and behold, lots and lots of people are addicted to opioids. Well, right? And so, the state of Oklahoma files a multi-billion-dollar lawsuit, and where they get $572 million out of this judgment, which will be appealed for the next 20 to 30 years. Be tied up forever, but this is going to start happening all over the place. You're going to see more and more of these judgments. Towards the end of the semester, I will bring someone in to talk to you about multi-district litigation, or what we call MDL, which is very oftentimes where this kind of thing ends up, where everybody's suing the same people over the same kind of stuff. And it all ends up in this big giant, well, I'll let them describe it because they can describe it better than I can. And the word that I'm coming up with is not one that's appropriate to use in front of a class, but it's a big giant cluster of something. You know what I'm talking about. So, when I said, what does this remind you of? I think that with doing the mathematical breakdown of this is going to pay compensation, or it equals compensation, because probably these people will never get paid ever. It equals compensation for about 58 people in the state of Oklahoma who've been affected by the opioid epidemic. Right? That's not all the people in the state of Oklahoma that have been affected by the opioid epidemic. And how long do you think it took for big tobacco litigation to play out? Ever heard of that stuff? You guys know what happened with that? How long between the time that researchers at Big Tobacco knew that tobacco was harmful and addictive, up until the time of when there was a payout of some kind as against those tobacco companies? How long do you think that took?
20 years?
20 years?
20 to 30 years.
20 to 30 years. 17 years?
50 years.
You're getting closer. I think it's more along the order of like 80 years, right? Somewhere between 50 and 80, depending on who you believe on when the researchers at the tobacco companies knew that the stuff they were putting out there was way more harmful than they were telling people with ads like this. Okay. So it's perfectly fine. So, will anyone that's actually been affected by any malfeasance by the pharmaceutical industry, if you accept that there was any malfeasance by the pharmaceutical industry, will any of those victims ever see a payday? Yeah, probably not. But that's the majesty of the law. All right. Amended pleadings. Where are we? in our imaginary, welcome, in our imaginary hypothetical lawsuit that we're doing here, you filed a complaint. The complaint has been served. Now you realize, whoops, I screwed something up with that complaint. You put a wrong fact in that complaint. Okay? Later you find out, oh wait, that thing that I put in that complaint was wrong. Right? How do you fix it? You did even a single page of reading for this class, you know how to fix it. How do you fix it? What? How do you fix it? Yeah.
File a motion to amend,
Well, do you though?
or just file a.
You amend the pleading. I agree with you on that. Okay? You amend the pleading. You amend the pleading. You can amend the pleading, right? If you got something wrong, you discover something later on. What if you got it wrong just because you're careless? Just because, whoops, I forgot to put that in there. Can you still amend your pleading? Yes? Yes? Anybody say no? Yeah, you can still do that, right? You screwed it up, you screwed it up. What about an entirely new legal claim? Can you still amend your pleading to include an entirely new legal claim that you didn't file your first complaint? Who says yes? Who says no? Yes, you can. Yes, you can. What does the rule say? What does the rule say? Yeah.
It has to relate back.
Well, it doesn't have to relate back. It doesn't have to relate back, does it? You might want it to. It doesn't necessarily have to. We'll talk about relating back here in a minute. We're not on that planet yet, right? Yeah.
You get 21 days.
You get 21 days. We'll also talk about it. I'm talking about the bare capability of just changing the complaint that you've already filed to include a separate legal claim. That's okay, because what the rules contemplate is any reason, basically, that you want to change it. Any reason that you want to change something. Now, there's parameters to that. Right? If the defendant has already answered, that sort of complicates things, doesn't it? Let's go and look at, well, let's just stay right here. 15A. The defendant hasn't responded, or you're within 21 days. The federal rule, pay attention to this, the federal rule, right? You're within 21 days of when you filed it. It's okay, right? You file a notice of amended complaint. And why is it a notice of amended complaint instead of a motion? Yes, you can do it without the court's permission. Why do you file a motion, right? We did motion practice last week. Why do we file a motion? Well, we're asking the court to grant us something. Give us this thing. Right? But what does the rule say? Yeah.
They pretty much have to approve it as long as it's.
You get to amend once as a matter of course, yes, right? Yeah? As a matter of course. That means you don't gotta ask the court for it. Within 21 days, as long as your defendant has an answer, right? Let's look at what that looks like. And examples abound, and they will all look different. Okay? They might all look different. Here's one out of the Central District of Illinois, filed by the United States of America. You think their litigators know what they're doing? Generally speaking, yeah. Right? Plaintiffs notice there's all this green stuff. You understand all this green stuff at the top? That's put in there. You don't put that in your pleadings. Everybody gets that, right? The court does that. When you electronically file, that stuff just gets automatically stamped on it. Okay? So as you look at these example pleadings, don't think that you've got to go in and put in all that stuff. You don't have to. Okay? But the heading, right, everything from United States District Court on down, that's on you when you draft. So you got the plaintiff, you have the defendant, title of the thing, right? Plaintiffs of the United States of America, identifying who they are, and then they say the first amended complaint is filed as of right under Federal Rule of Civil Procedure 15A. Now remember the last time we were in here, I told you got to have some sort of statement of jurisdiction. That doesn't mean that you set off a whole separate section that says statement of jurisdiction for every single thing that you file with the court. But you're telling them that they have the power to do what you're asking them to do. Okay? You're reassuring the court. Courts like to be reassured that they can do the thing that you're asking them to do. It makes them more likely to do it. So if you say, here's the rule that I'm relying on, 15A, 15A3, right? They even go farther. Plaintiffs advised Dish of this filing and have agreed to Dish is seeking a week's additional time to respond, saying, look, court, we're getting along. No problem with this at all. Just go ahead and enter it. Enter our amended complaint. Okay? They go on to say the First Amendment complaint. Can everybody see that? First Amendment complaint makes these changes, and then they specifically set forth what those changes are. Well, welcome. Hello. Everybody coming in late today. Then you got your signature blocks and your certificate of service. You don't have a certificate of service on your original complaint because you don't know who opposing counsel is. But by the time you file this notice of your First Amendment complaint, you do need a certificate of service because you know who opposing counsel is. Maybe, right? Another signature block there. All right. Questions about that? We're good, right? Simple, easy. If you're within 21 days, under the federal rules of when you filed it, the defendant hasn't responded. Well, what if the defendant has already responded? File my complaint, and 5 days later, the defendant, who has nothing else to do, files an answer. Now what? Do you get to amend your complaint? If so, how? Who's got an answer for me?
You can amend, but don't they get a chance to amend their response after that?
That's true, yes. Do you file a motion to amend or just a notice?
It's a motion at that point, right?
At this point, still a notice. Still a notice. You can still do it as a matter of course. Okay? Can you file it as a motion? Sure, why not? Right? Not going to hurt you. But if we're not beyond 21 days from when the defendant filed that answer, you still get to do it, get to amend your complaint as a matter of course under the rules. Okay? That's important. Everybody got that? Defendant files a motion to dismiss 5 days after you file your complaint. Then what? Can you still amend your complaint as a matter of course? You just file a notice to amend your complaint? Who says yes, you can do that? Nobody? Okay, a few of you. Who says no? I'm not sure. Is there? Yeah, you can. You can. There's a lot of room to play here if you screwed up your complaint. That's the thing to remember. There's a lot of room to play here. You can correct your mistakes. In civil litigation, as opposed to criminal litigation, there are very few things that if you screw it up, you can't go back and fix it. Yeah?
So basically, whoever, you would always have 21 days to respond or to file a notice to bring in a complaint, as long as, like, from whenever the last attorney sent something.
Yes, I think that's a good way of looking at it, right? So if there's a substantial filing, I have a slide on this too. If there's a substantive filing by the defendant, right, if they file anything substantial, mark your calendar for 21 days after that. Like, that's really the thing to remember. Mark your calendar for 21 days after you file your complaint, right? But really, the big clock that starts to tick is 21 days from whenever defendant files. Okay? That's the bottom line. That's the takeaway from the first part of Rule 15. Okay. What if it's been more than 21 days after the defendant's response? Thinking, oh my God, I'm really screwed now. All right. Walk back through it procedurally. File your complaint, get it served. Defendant answers. 30 days after the defendant answers, you're like, oh man, I should have included this other claim. I have an entirely different legal claim against this defendant. I didn't put it in my complaint. What do I do now? Welcome. Just wander in wherever you want, you guys. It's fine. Right? What happens? Then what do? Time to panic? Time to notify your malpractice carrier? Is that what you do? Yes? You make a motion. You just ask the court to let you amend it. Right? That's when you make your motion. You amend within 21 days. Think about it this way. Different scenario. Okay, file your complaint. Defendant answers in 5 days. No, back up. Scratch that. File your complaint. 10 days later, you realize you made a mistake. You file an amendment. 5 days after that, defendant answers your amended complaint. And in that answer, you realize, oh, I screwed up my amended complaint. Then what? You're still within 21 days. Still within 21 days. You've already filed an amended complaint. Now what do?
You have to motion now?
What's that?
They only allow one one free amendment for matter of course, so now you have to motion.
You get one free swing. See that in the rule? Once as a matter of course. You get one free swing, and then you got to ask the court. Then you got to ask the court. Then you got to make a motion. Okay? Got that? That's simple, right? It's easy. Sometimes you can do it without asking the court. Sometimes you can't. There's a motion for leave to amend look like? Well, in the federal system, not a whole lot different from the notice. This is without all the electronic filing book. Heading, parties, title. And then what you have after that is sort of up to you. You have an introduction, because this whole thing is basically a memorandum attached to the motion. Do you have to have all that? Not necessarily. Right? Can you just cite the rule and say, sorry, Judge, we screwed this up. But the rules say, you should let us amend our pleadings whenever justice requires, and justice requires it here. And we're within the statute of limitations anyway, so no big deal, no harm, no foul. Yeah, that's the way that's kind of the way a lot of these read, okay? Kind of the way a lot of these read. Now, if you're outside of that statute of limitations, which we'll talk about, That's a different story. See this? See how they did this? Easy, right? Easy. You can do that. You can do that. If you're at your summer job, between second and third year, and they say, hey, we need to make a motion to amend our complaint because we screwed something up. You'll be like, yeah, that's easy. I can do that. And then you'll be the hero of your law firm. Heroine, as the case may be, of your law firm. And they'll invite you to come back after you graduate and they'll pay you $500,000 a year. That's the way it works. Okay. What's the rule in Kentucky? Take a guess. 1501. It's Rule 15, right? And all the .o somethings that you have in there. Let's have a look at that. And now, would you imagine that Kentucky Rule 15 is exactly the same as the federal rule, or would you imagine that it's annoyingly slightly different?
Annoyingly slightly different.
CR 1501 amendments. Party may amend his pleading once as a matter of course at any time before a responsive pleading is served or if the pleading is filed with no responsive pleading is permitted and the action has not been placed upon the trial calendar, it may so amended at any time within 20 days after it is served. Oh, that's annoying. How about that? 20 days and not 21. But of course, you won't be the kind of lawyer that waits until the last possible day and then realizes that the last possible day was yesterday to file an amended complaint, right? No one would ever do such a thing. You're going to have busy lives and busy practices, and it very often happens that your stuff gets filed at the last minute. Those of you that have worked in especially small law firms know this reality, right? Happens. So you have 20 days here instead of 21, 10 days here instead of 14. Okay? Just pay attention to that. Just pay attention to the state rules and the local rules, because there may be a local rule on how to amend pleadings, right? Maybe. You don't know until you look. Make sure to look at all those rules before you think you know what you don't know. Okay, let's don't get confused about this. You make a motion, assuming you're outside of your 21 days, okay? You can't amend as a matter of course. That's the planet we're on here. Do you have to notice the motion in the Kentucky State Court? You have to notice it for their motion hour docket, like we did in here last Friday. Remember, we did a notice motion order? Do you have to do that in the Kentucky State Court, or can you just file a motion? All right. Who says notice it? Gotta notice it. Who says just file the motion? Who's just guessing? Yeah, okay. Almost everything has got to be noticed for the motion, okay? Almost everything. Check your local rules, but almost everything. The only thing that you might not have to notice for motion hour through most of the state of Kentucky is a dispositive motion of some kind. Motion to dismiss, motion for summary judgment. But in many places, not Louisville, but in many places, you have to notice those too, okay? Isn't this fun? Questions about anything we've covered so far? You can also, instead of getting the leave of court, you can ask the other side, hey, can I file this amended pleading? And how do you think that's going to work out? Well, phrase that very sort of pessimistically, I guess. But you'll find a lot of cooperation among lawyers, as long as it's the kind of cooperation that isn't going to screw your client, right? So, if the other side thinks that the judge is going to be predisposed to grant your motion, they might just say, yeah, let's show the judge we're getting along, and let's not make him mad, that kind of thing. And why not? Why spend the extra money and expense and heartbreak to brief this thing? You know, maybe, right? Maybe they'll agree. But if you're outside, if you're the plaintiff, you're outside of your statute of limitations, and you want to make an amendment to something that you totally dropped the ball on, that should have been filed 2 years ago, I'm probably not going to give you the permission for that. Probably not. You're going to have to go and grovel to the court. Talked about that. Okay, our problems. 421. We've already covered this stuff. Easy, right? Hillary files a complaint against Bill. Before Bill answers, Hillary files an amended complaint, adding new claims, seeking an additional $10 million in damages. Why did Hillary have a right to do this? Give me chapter and verse.
Can you file an amended complaint as a matter of
Rule and subsection, please. I want this stuff when I finally understand that. Say again? 15A1. 15A1. That's as easy as I can make it, guys. It's as easy as it gets. So if you're lost on this, maybe time for a trip to office hours. Okay? Let's talk a little bit more about it. Number 2. Hillary files a complaint. Bill files a motion to dismiss. Hillary says, oh shit, you're right. Before the hearing, Hillary files an amended complaint, which moots the motion to dismiss. Let's jump ahead to Iqbal. Who knows what I'm talking about when I talk about Iqbal? Hopefully all of you, because we covered it in here. Somebody makes an Iqbal motion. A motion to dismiss under Iqbal/Twombly. Says you have not raised a, what is the standard in Iqbal? Plausible, I heard it. Plausible claim for relief. You haven't connected your facts up to your law such that it creates a plausible claim for relief. Hillary gets this motion to dismiss and says, oh shit, you're right. And then goes back, tweaks the complaint where it does state a plausible claim for relief, and refiles. Bill has spent all that, put your defendant's hat on, Bill has spent all that time and his client's money and energy on drafting this motion to dismiss, and then it just goes up in smoke. He's got to do it all over again. Is that the way it works? Yeah, those places, that's the way it works. That's it. Make sense? Can we go on? Problem 3. Hillary files her complaint against Bill. Served on September the 15th. Here's where the math comes in. Enters the complaint and has it served on Hillary on October the 3rd. No counterclaims. Remember, this rule, this amendment rule, applies generally to pleadings, right? Not just complaints, but answers too. You want to file an amended answer, the same rules apply. Okay? Answer contains no counterclaims. October 20th, Bill files an amended answer. Corrects some errors in the original answer. What rule gives him the right to do that? Chapter and verse. 15A1. A. Thank you. Yes. 15A1. Big A. This isn't confusing, right? We got this. Easy. Easy. If it is, that's okay. We'll fix it. But make sure you get it fixed before you disappear down the rabbit hole of the stuff that we're going to do the rest of the semester. Erie, claim preclusion, and fun stuff like that. Okay, the Irwin case. Irwin versus McDermott. Why do we care about this case? What's the point? Why did I have you read it? Because you read it, right? What's the point? Why do we care about this one? Yeah.
It kind of highlights how the court has discretion in maybe like over deciding certain.
Yes. In what circumstances?
I think well, in this case, like if a party kind of deliberately goes out of try and sort of like pull one over on the other party and
Yeah. Who do you not want to be in this case? You don't want to be that defense lawyer, particularly. But what is the court allowing the plaintiff to do here? What's the court allowing the plaintiff to do? Why do we care about this in the context of Rule 15? Yeah.
It's after the statute of limitations.
It's after the statute of limitations, right? Because the amendment is being made to the complaint after the statute of limitations is already run. This is where the Rule 15 stuff gets a little stickier. It's also where it's more important to you, especially if you're plaintiff's counsel or defense counsel. You care about this more. Why? Because it's life and death for your claim. What if Irwin had come out a different way? We'll jump ahead. Could the court have gone the other way on this? Could the court have said, no, I'm not going to let you amend the complaint, you just lose? Because that's what would happen. Everybody sees that, right? If the plaintiff wasn't allowed to have this amendment, they lose the case. They don't have a defendant. They don't have the proper defendant involved in the lawsuit, and they can't sue against the proper defendant anymore because they're beyond the statute of limitations. Everybody's with me on that, right? Okay. Could the court have said, gone the opposite direction? Could the court have said, no, we're not going to let you do that. You just lose. Take it up with the Court of Appeals. Yeah. Yeah. Yeah, what's the most important rule of civil procedure? Said it before. Know thy judge. Somebody's paying attention. Good job. Know thy judge. They have a lot of power over you. All right, so procedurally, before this opinion happens, you understand what's happened here. We've already sort of talked through it. Plaintiff files the complaint. Defendant kind of screws around for a little while, and then ultimately, after the statute of limitations runs, files a motion to dismiss. You didn't serve the right defendant, and now, oh, the statute of limitations is run. And what's the other part of the defendant's argument? Not just that the statute of limitations is run, but what else? There's two pieces. Sarah?
He also says that the amendment deadline is passed.
Yeah, the amended deadline. What does that mean? What are they talking about? Where is it? Very top of 423. The deadline for amendments set by the pretrial order has passed. We haven't gotten there yet, but what are they talking about? Does anybody know?
Don't they normally have like a pre-trial conference where they'll set deadlines for discovery amendments and such, and he's saying that the court set this date, he didn't amend by the
Yes, yeah. So under 26, under Rule 26, you got to, we'll cover this later, but you got to all get together and confer on a litigation schedule, right? Sometimes the court will just issue, it's annoyingly different jurisdiction to jurisdiction. And this doesn't usually happen in state court, depending on the state you're in. Right? But in federal court, under Rule 26, you're required to confer and submit a litigation plan to the court, which we'll look at. And that litigation plan sets out deadlines, usually, for amended pleadings. Amendments are due on such and such date. And the defendant here says, well, he blew that date, so sorry about your luck. Also blew the statute of limitations, so we should just win. We touched on it already. The big rule that they're talking about here is C1C, right? 15C1C. And there's a lot of language packed into C1C, but what's the point? What's the point of that rule? There's this nice big block quote in the Irwin case that sort of sums it up. But really the whole second part of the opinion sums it up. What's C1C? What's the point of that rule even being there? What's that trying to tell litigants?
If you made a legitimate mistake, if you really thought you were safe, then as a defendant, then there's a strong interest in, I guess, in protecting you in that way. But if you purposefully was trying to escape, then you won't let you do that.
Boil it down even more. In lay terms.
So they say they want to balance the defendant's interest in having the suit dismissed with the plaintiff's interest in getting the suit resolved.
Well, there's that. Yeah. The point of C1C and all that you see in that rule is basically don't play games, right? Don't make this into a game. What it says in that block quote right at the top of 425. A suit at law is not a children's game, but a serious effort on the part of adult human beings to administer justice. Reasonable minds can differ. Right? The point is, don't waste our time. Don't waste the court's time with this stuff. If you knew that there was a lawsuit out there, you knew you should have been defending it, don't waste the time. Don't waste our time with this stuff. Okay? We got better things to do. Don't play games. Let's see. Little things. You can amend your pleadings to conform with the evidence at trial. That's point 15B, right? You don't really want to rely on that strategy, but you can. Right? When you're at trial, say, look, the proof has come out this way, and so I'm going to go ahead and amend our complaint. And it's all imaginary, and it happens right there on the spot. But does it really happen? Yes. Yeah. It does. The new pleading supersedes the old one, meaning, I can tell you horror stories about this. Include all the language that you want to keep from the first complaint. So if you're filing, or answer, if you're filing an amended complaint, for example, right? Put all the stuff in from your first complaint that you had in there to begin with. Don't just put the new stuff and say, here's the new stuff we want to add to our complaint. And that might seem kind of elementary, or at least incorporate by reference, right? You learned what incorporation by reference is in contracts or something, right? Incorporation by reference, you're saying, all right, I'm incorporating all the stuff, I'm bringing all the stuff that I said in my original complaint into this amended complaint. I don't want to retype it, I'm busy. But I'm going to incorporate it by reference. Okay? So since I'm referring to that old complaint, it is hereby incorporated into my amended complaint. Because if you don't do that stuff, and I have seen this happen, I swear to God, if you don't do that stuff, you'll then be subject to a motion for summary judgment or a motion to dismiss based on the fact that your complaint doesn't have enough stuff in it, right? Because the court only gets to look at the amended complaint. The amended complaint supersedes the original complaint. And so if somebody really has it in for you, if your judge really has it in for you, they can make your life fairly miserable. Yeah.
I just had a question. If you amend the complaint, can you also remove claims you no longer wish to pursue if it comes out that
Yes. Yeah. Sure. Yes. Absolutely. Yeah. And that touches on this, right? The new pleading supersedes the old one. So if you decide that intentional infliction of emotional distress claim that was filed by predecessor counsel is the stupidest thing I've ever seen in my life, let's get rid of it, which you might do, right? You might. 9 out of 10 times probably a good idea. Yeah, you can do that. Yeah. Ellen.
When you say you incorporate the reference, you don't like attach the old one as well so they can see it, or?
You can. Yeah, you can. I'll get to that. So, the point of 15C is that relation back is going to happen. I kind of think that your book muddles this a little bit and makes it a little bit more confusing than it needs to be. Like the point of 15C and the point of amending your pleading, especially after the statute of limitations, is that it relates back, right? An amended pleading that doesn't relate back is probably not going to do you a whole lot of good. But that is essentially like going back in time and saying, all right, whatever I should have filed in my complaint a year ago was actually filed in my complaint a year ago. Everything's fine now, right? All right, here's your scenario. Ready? You got a whole half hour to do this. Plenty of time. You're in the federal court in Louisville. You represent the plaintiff. You accidentally sued the wrong defendants. No answer by defendant. Filed suit last week. Any other facts that you want to have in there, you can make them up. Give me something that looks like something that you could conceivably file in the federal court to handle this situation. Everybody see that? You're on a monitor? Because I can't make it bigger. You can. Groups of 5 or fewer, please.
Hey, how am I gonna use my microphone? Yes.